Hello, I am attorney Masa Sam Foray, and I am the owner and founder of the Foray Firm with offices in Houston, Texas and Chicago, Illinois. And I'm here to talk to you about all things related to immigration. So today we're going to be talking about who is ineligible for a green card altogether. All right, and so if you've come here with a visa, and you plan to stay in the United States, and obviously your goal is to achieve and to obtain a green card and to stay here legally as a lawful permanent resident. But there are some people who are simply ineligible. There is no immigration attorney or immigration court who can help you to stay here if you have committed certain crimes. Anytime there's an immigration application, including an application for a green card or lawful permanent residency, there is a sponsor and there is a seeker. The sponsor is the person who has either their own green card or they are a U.S. citizen. In any event, they are the person who is lawfully and legally in the United States who is sponsoring the seeker to be able to obtain a green card. The sponsor cannot sponsor you if they have committed certain crimes and they have a particular criminal record. Their crimes cannot include kidnapping, solicitation of a minor for sex, child pornography possession, and various sex crimes against minors. The seeker, you cannot be a seeker and you will never obtain a green card in the United States if you have crimes involving drugs, aggravated felonies, crimes of moral turpitude, including murder, rape, fraud, and animal abuse. This is America. Animals have rights. If you have been convicted of any crimes that I've listed, including animal abuse, then you are likely not eligible for a green card. And I want to make a note that aggravated felonies do not necessarily translate into an actual felony or an aggravated felony in your state court. Remember that immigration is federal, and so the state laws and the state courts and the state criminal code in which you reside or which you would have committed the crime or received your conviction does not necessarily translate and equates to the federal definition of aggravated felonies for purposes of immigration. Okay, and so there are very specific aggravated felonies that may honestly be misdemeanors in your state, but they are considered aggravated felonies for purposes of preventing you from being able to obtain a green card. So make note of that, and if you have any questions, of course you can contact us and we'll try to direct you further. The statistics are that every year USCIS processes over 800,000 applications or 800,000 I-130 petitions by a relative. And of those 800 plus thousand I-130 applications, over 50,000 of them are denied. So what we want to do is empower you to make sure that you know your rights and to make sure that you are not in that 50,000 of denials that are processed by the USCIS every year. If you are denied, however, you may still have rights. You need to immediately consult with a trusted immigration attorney. And when I say immediately, I mean ASAP. Because in many cases, you only have 30 days as a matter of right after you receive your denial in order to appeal the decision. You might have legal remedies available to you. You might be able to get a waiver, which is also known as a form of legal forgiveness for any issues that were identified. But in any event, once you receive a denial, if you are unfortunately one of the 50,000+ applicants who are denied, please consult with an immigration attorney as soon as possible and make sure you know your rights, make sure you exercise your rights, and make sure that you have done everything possible to stay in the United States if that is what you choose to do. Thank you, and I hope that this was helpful.